Don't do this often, but I really want to focus on this case, the Supreme Court decision from last week, which was between Catholic Social Services and the city of Philadelphia, and the court ruled 9-1 in favor of Catholic Social Services, saying that the state, or the city rather, could not exclude them because of their belief about marriage. Now, as I mentioned, in fact, coming up, we're going to look about what's the way forward. We're going to look a little deeper with this with former U.S. Solicitor General Ken Starr is going to be joining us. But for right now, Travis Weber, Vice President of Policy, is here. As I mentioned, going into the previous out of the previous segment into the break, many are celebrating and at the same time lamenting this decision. How can that be? Travis Weber joins us now. Travis, how can it be that, this was a case that many are celebrating a 9-0 victory for religious freedom, but at the same time lamenting this decision that it does not fully support religious freedom? How is that?
Yeah, Tony. So basically, you look at the result of this case, it's unanimous, 9-0. It's a good result in favor of religious freedom. We want to celebrate that the court ruled that this agency does not, has a free exercise right against the city of Philadelphia's behavior here, where they were going to grant an exemption for other groups, but not Catholic Social Services. However, despite the victory, you look at how narrow it is, how much the court basically sidestepped the important underlying questions in the case, how the court failed to address the need for the Smith case, a free exercise precedent, to be overruled. You look at all those factors, and it's concerning because the court could have taken a stronger position here, and there are issues coming down the pike the court is going to have to address. And so we look forward with concern to those issues which remain that the court is going to have to address in the years ahead.
I mean, when a case like this, religious freedom, I mean, this is a fundamental freedom. When a case like this, very similar to abortion, when a case like this gets to the Supreme Court, generally you're anticipating a major precedent that would affect, in this case, religious freedom across the board. But as I understand it, in this particular case, it was narrow, and that it was a huge victory for Catholic Social Services and other entities there in Philadelphia. But it really doesn't set a precedent. It leaves in place a previous precedent that in many ways limited the free expression of religion.
That's true, Tony. The Smith case holds that laws that are general and neutrally applicable that the government puts forth can stand without violating the free exercise clause, even if they burden someone's religious faith. And that precedent has been with us since 1990. Congress passed the Religious Freedom Restoration Act in response to the Smith case, but to this day, it is our leading modern, in the modern era, Supreme Court precedent on the free exercise clause. And this is what the dissenters pointed out in the Fulton opinion. Justice Alito penning a long dissent outlining why Smith should have been overruled here, joined by Justice Thomas and Justice Gorsuch, and noting that we have serious religious freedom problems in this country today. He mentioned some of the other current issues, the Jack Phillips case and others, and calling out that the Smith precedent does not cleanly deal with those issues, does not protect them. And a stronger, a better way forward would be strict scrutiny, which says that when someone has a sincere religious belief that's been substantially burdened, the government then has to show a compelling interest that's narrowly advanced in order to allow its regulation to stand. This is a better standard for religious freedom. So the dissenters pointing out that there's going to be continued problems the way ahead, and we'll have to wait and see what the court does in the years to come.
Yeah, you mentioned Justice Alito. As you said, it was a long opinion that he wrote in his dissent, or adding comments to it. One paragraph, he said, after receiving more than 2,500 pages of briefing and after more than a half year of post-argument, the court has emitted a wisp of a decision that leaves religious liberty in a confused and vulnerable state. Those who count on this court to stand up for the First Amendment have every right to be disappointed, as am I, end quote. It's like, all right, we're fighting these battles one at a time instead of a major winning the war over religious freedom. They're just these little skirmishes. And so in this case, social services, Catholic Social Services won, but the bigger protection of religious freedom is being held to be decided for another day.
That's true, because in this case, all Philadelphia has to do now is go back to the regulatory drawing board and say, we're going to remove the exemption that we provided in other areas of our approach to these contracts, and then come back into court and say, well, look, we're being generally and neutrally applicable. And under the Fulton decision that this court issued, we don't know what the court would do in the face of the city saying, well, we're neutrally and generally applicable, because the court basically relied on the fact that they have this exemptions in their current policy to say, well, this violates the free exercise clause, which is fine. It gets us through the result in this case, but it's narrow, and the city can go and change that, and then we're back in court. The court did not address whether a substantially burdened belief can stand in the face of a compelling interest. It did not decide whether the interest here was compelling. And that's really the question we're going to be facing in the years ahead under statutory approach like RFRA or the free exercise clause when these cases are raised again.
But on the positive, in the positive ledger on this one is that what we are seeing is that when these cases do make their way to the Supreme Court on religious freedom, more times than not, we prevail for religious freedom because of that constitutional foundation. It's just it's a long, hard slog to get to the Supreme Court to defend this fundamental freedom, but it should be a reminder to everyone that we need to stand for and defend this freedom. Travis Weber, thanks so much for joining us.
Thank you.